Hello and welcome to Data Matters with me, your host Vicky Gilwar, and my business partner Steve Wright. Hi Steve.
Hi Vicky, good to be here again.
Indeed. So we are moving away for the first time from our 12 domains of GDPR, and we're really excited to welcome two immensely qualified lawyers today. We have Rocio de la Cruz. Rocio is European Privacy and Information Law lawyer from Gowlings. Hi Rocio.
Hi everyone, I'm very excited to be here today with you.
Brilliant. We're so glad to have you with us. And on the end of the phone, we have Helen Davenport. Helen is also from Gowlings, and Helen's a partner. Hi, Helen.
Hi, everyone. Delighted to be here as well.
Excellent. So, together with Steve, Helen and Rocio are going to help us explain what is meant by vicarious liabilities from a legal perspective and also in practice. And in today's discussion, of course, we're going to be looking really closely at the Morrison case and the subsequent appeal. And we'll be asking what the landmark judgment actually means for the cybersecurity and privacy sectors. We'll also think about and consider how this affects the relationship between organisations and their employees and third parties. And as usual, we'll be inviting you to ask your questions. So please do submit them through the live Q&A. So I'm going to start by asking this question of you, Helen. Can you actually help us unpack what vicarious liability means in legal terms, please?
Sure, Vicky. So vicarious liability it's a common law principle where one party is strictly liable for the wrongs committed by another person where it wasn't at fault itself, or even though it wasn't at fault itself. So it's therefore a form of secondary liability. And it's long established that there can be vicarious liability in an employment context, so an employer can be liable for the acts of employees, and it may apply in other cases where there's a relationship similar to an employee relationship. Now, those thinking sort of on the face of it, well, it's unfair to be liable where an organisation isn't itself at fault, it might be helpful to explain that this imposition of liability on a no fault basis is policy driven, and key considerations are that an employer's economic activities are going to carry the risk of harm to others. So if an employer is going to get the upside of that activity, then fairness requires that those responsible should also be liable to anyone harmed during the course of that activity. Another factor is that employers generally have larger assets and means to offset losses, and also the idea of imposing strict liability on employers encourages them to maintain standards of good practice by their employees.
Thank you, Helen. That was really clear, and of course the implications are potentially quite far and wide-ranging for an employer, such as Morrisons. And I think it would be really helpful if you could just unpack what the potential implications are. Or were, for Morrisons. I think most of us probably know what the eventual outcome was, but the chronology, the lead up to those events will be really helpful.
Sure. So as you say, I mean, this obviously the case involving Morrisons, and in particular their rogue employee, Mr. Skelton. Now we're going back a few years. In November 2013, he was tasked with transmitting payroll data for Morrisons' entire workforce to Morrisons' internal auditors, a task he'd also been asked to undertake the previous year. Now he did this in 2013, but he also kept a copy of that data for himself, publishing it on the internet, intent to pursue his own vendetta and do Morrisons damage. And the context of the court case is that a group of the affected individuals brought claims against Morrisons for breach of Section 4.4 of the Data Protection Act 1998 for misuse of private information and breach of confidence. And the High Court delivered its judgment back in December 2017. Now, it rejected the idea that Morrisons bore any primary liability to the employees that have brought their claim. It concluded that Morrisons had taken the appropriate and technical organisational measures to protect the data in question, save in one respect, which the court found was not causative of the damage caused. But the trial judge did, however, find that Morrisons, as Mr. Skelton's employer, was vicariously liable for Mr. Skelton's actions. Now, during the course of that first trial, Morrisons had argued it couldn't possibly be vicariously liable because although what Mr. Skelton did was closely related to the course of his employment, he wasn't actually authorised to do it. But the court rejected that, said it was closely related, and therefore Morrisons could be vicariously liable. Now, in the course of that first trial, the court didn't consider what the claims were worth because the trials of liability were split. But the finding had the potential to be very expensive for Morrisons, as even if each claimant was only awarded a small sum, when you multiply that by the number of claimants, you get a potentially very big bill. So Morrisons then appealed that case to the Court of Appeal and ultimately to the Supreme Court, which is the background to the decision that we got earlier this year.
Excellent. Thanks so much, Helen. And you know, it is a long and troubling story, and I'm sure that in the end, you know, Morrisons probably did somewhat breathe a sigh of relief, as did other organisations, but it took a long time to get there. And of course, these things are probably going to be looked at in future on a case-by-case basis. So, Steve, you know, what are some of the problems that businesses are going to have associated with fulfilling these obligations going forward?
I think it goes back to the whole compliance regime, Vicky. You know, every organisation now has to have in place and be demonstrable a sort of fairly robust compliance regime, including things like control frameworks, risk management, and the obvious ones around records of processing, etc., etc. But I think the key here really is around now thinking more broader than what, you know, this case was really testing, because it made organisations really think, well, hang on a minute, we've relied on, if you like, controls that are common sense controls to be put in place. So, you know, things like authentication and, you know, access control and all the good things you would expect to see, training for Mr. Skelton, etc., etc. But what this implies is that, you know, actually, with all of that, you could still potentially be liable. So it was, fortunately, for the benefit of organisations, an absolute breakthrough that the Court of Appeal overturned the earlier decision by the High Court. And I think, you know, if, you know, when I was a DPO, we were all watching this very carefully, because we were thinking, well, hang on a minute, how far can we take this? What are we meant to do? Start doing background checks on some of our people, you know, who have got this level of access to the, if you like, the keys to the kingdom? How far can you take this? How far can that liability stretch? And so I think the implications for this were worrying, and now everyone sort of breathed a collective sigh of relief when this finally went through. I mean, certainly when I was at John Lewis, we were particularly concerned about the implications from this, and the HR director that I was working with was very worried. So I think it stems back to that broader conversation about how you're demonstrating compliance and thinking through. And again, it sort of goes back to the whole defensible position, but them thinking, hang on a minute, what could be the possible scenario? And look, for years we've done this, certainly in the cybersecurity side, but increasingly I'm seeing this with the clients through Cruz culture, that we're talking about different types of training scenarios. We're talking about what if scenarios, which, you know, current pandemic aside, we never thought we'd be asking ourselves these sorts of questions. So this has been a real wake-up call for many organisations throughout, not just the UK, but throughout the whole of Europe and beyond.
So in which case, Rocio, can I just come to you? and ask you, what are the implications and legal challenges that you've witnessed for your customers following the Supreme Court overturning the previous ruling?
Yes, so it's pretty much in line with what Steve was saying. So this is a wake-up call for all organizations. And indeed, it goes beyond training. So the first question that we were discussing with clients, our clients was asking, since the beginning of this case, since the High Court resolution, is how this affects my business. And it's very much in line with what Steve was saying. How far do I need to get when I'm doing these risk assessments, and how can I balance this? Because if that means more monitoring actions over employees, of course you need to balance those actions against the employees' rights to privacy as well, which is a challenge. And what we are doing, and in particular during the last year and since this resolution, is considering and including the vicarious liability element in any risk assessment, including data protection impact assessment. We may arrive at a conclusion in which you consider that you may need a data protection impact assessment not only when you are, for example, contracting with third-party service providers in a high-risk area, but also when you are instructing certain employees depending on their role. And that's something that indeed is a new challenge and kind of a new element and a new task within the data protection compliance world to add to our long list of things that we need to review, keep building up. And also it's kind of coming back to the elements of vicarious liability. I think that one of the things we are starting to do is considering as part of this risk assessment the first element or the first stage of where vicarious liability applies, whether or not it is in the context of employment. So that may go beyond employees, that may include other type of workers, for example, a self-employee worker that it's self-employee, but actually in practice is not allowed to market their services or deliver their services to anyone else. They are beyond the instructions of the company. They are an integral part of this business, of the company that is employing these services. And in the end, it's kind of a very look-like employment relationship. So we need to think beyond the pure employee and the extent to which there are high-risk data processing in these scenarios to assess the vicarious liability elements. So that is one element. And the other one, which is, I think, the challenge, is to consider the connection between this possible wrongful act that you are envisaging that is likely to happen when you are doing this risk assessment before anything happens, and the connection between the employment relationship and the task allocated to these employees, and the extent to which the employee was actually authorized to do that. So we are asking ourselves and our clients questions as to whether the employee is using the data on behalf of the company for the company's business, whether the company is creating a risk by allocating that task to that particular employee, and like Steve said, the extent to which you need to actually do these background checks and keep them up to date, and whether or not how intrusive this is and how fair this is and appropriate, and the extent to which the employee is acting under the control of the employer, and that is clear. So you can demonstrate that they were acting beyond that. Of course, if there is a personal intention, as it happened in Morrisons, that there was this personal intention of potentially revenge, supposedly revenge against the company, it seems that in this context, it's going to be more easy for the company to argue that that goes beyond and sits out of the context of vicarious liability.
As you say, that's really important in terms of the plugging in this this requirement into the privacy risk assessment process. Steve, before I continue, I think you've got something.
It's not just me, actually Helen's champing at the bit as well, but I'm going to let Helen go first because she's imminently more qualified than I am to answer that. But I was going to say something, but I'm going to let Helen speak first. So over to you, Helen.
Thanks, Steve. I just wanted to sort of endorse the importance of everything that's just been said there in terms of measures, because of course the decision was good news for Morrisons in terms of by the Supreme Court not being found vicariously liable, but on different facts the decision could have been different. And the court also considered whether you could have vicarious liability in a data protection context, and the court said that you could. So that means that employers may still be liable for data protection breaches where the employee is engaged, however misguidedly, in furthering the employer's business, and organisations may still be directly liable if they fail to comply with the security requirements to safeguard data. So there, there's good news in terms of the judgment, certainly for Morrisons and potentially for extreme scenarios, but there is still, the potential for liability there going forward on slightly different facts. So that the decisions ought to be taken with some caution, I would say.
Thank you, Helen. And I was just, Vic, I just wanted to comment on the fact that, look, having been responsible for both the information security and privacy data protection at John Lewis, I can tell you that most of these incidents that occur, breaches, incidents, are 70% of them are internal. So to Helen's point, we're not off the hook yet. We've really got to be thinking beyond the sort of traditional potential controls that we've had in place, and really think about those liabilities, albeit with Helen and Rocio's comments about sort of the monitoring and the extreme points of view. But I'm so, as a DPO and a sort of CISO, and many of my friends are, where does this stop? Where does it end? How, we've got third parties and we've got employees of those third parties. It's just, I was just helping an organization recently because they want to deploy their software development team to Spain. They're currently in London. It's costing too much, so they want to, and you just wonder whether this is yet another example of how, to what extent does that organisation become responsible for that third party's employment? Because going back to the sort of the background checks and making sure these people are okay, people can turn, just like Mr. Skelton did. He was annoyed. I was understood that he got passed up for promotion. And motivation is a funny thing, and it can turn what seemingly ordinary people into quite vindictive and nasty. So it's still a worry.
Absolutely, yes, Steve. And just sort of listening to all of you, then, as we sort of said to start with, it's a comprehensive topic, and it requires quite a comprehensive solution. As Rocio mentioned, harnessing the privacy risk assessment, the data protection impact assessment, plugging this requirement in, I think is really, really sensible. But as we all know, data protection is not just the data protection officer's issue, is it? And Steve, you mentioned security. This is kind of even more far-reaching, but it feels like, a really good opportunity to use this as an example if you're struggling to get buy-in for any sort of data protection issue around the business, because this is something that HR needs to be super plugged into, procurement, your whole supplier onboarding process, and just outlining the potential implications, as Helen said. Just because the outcome was positive for Morrisons, it's very clear that actually it is still an issue, though, and will still be looked at. So as with so many other aspects of the GDPR, people need to ensure that, again, they can demonstrate compliance. And employees, yes, we know, generally do want to do the right thing, but we also need to ensure that we've made them fully aware that all of the procedures are in place, they've been fully trained, they know exactly what they should be doing, and all those checks and processes are in place, so that it's quite obvious that if something does go wrong, and as we know, unfortunately it will, everything else has been done. So yeah, really fascinating topic. I think it would be great, Rocio, if we could kind of, I know we've started to unpack this with the inclusion of vicarious liability requirement in the data protection impact assessment, but what would good look like in a business in this area, a business that had actually understood the potential implications and the need to get this right? What do they need to have in place?
So I think that depends very much on the business structure, context, and the nature of the business and so on. But 5 steps in relation to the vicarious liability element that I recommend to follow is, like I said, first of all, identify the employment relationships. Second step, from those, identify the tasks allocated that are high risk, because as in anything in data protection compliance, you wouldn't try to do everything, so it needs to be a risk-based assessment and implementation of measures. Each one is going to be a challenge, so you better start by the high-risk ones. The step 3 is doing the risk assessment, trying to think of any action that may, under the GDPR and under this regime, may cause this potential vicarious liability for any possible tortious acts taken by these employees. What is the real and effective likelihood of that? And then depending on the nature of the business, either having a policy to decide who is giving instructions to whom, how and whether any further training must be carried out, or any other accountability documentation evidence that you create. I think the key is narrow down the context in which there is disconnection with the business in terms of processing that data. So anything going beyond that is most likely, or it's fabulous to demonstrate that, to argue that that went beyond the business employment context, and that is the connection lose these close elements that is relevant in this context. And even though you do all these things, I would still recommend as a last step to remain vigilant. So, and this is something that actually, you know what, we are talking today about vicarious liability, but I am feeling that now we are in a compliance time in which 4 years ago organizations started looking at GDPR, getting familiarized with the basic terms, discussing with the other parties the basic terms, trying to compromise on how each one is understanding what it needs to be done, because we are in a business global world in which there are many parties involved in one project, so you need to liaise with other parties, and we kind of have taken compliance in a survival phase. That's how I like to name it. It's kind of survival phase in which we have been just trying to do our best to comply with all the elements, to look international for these global companies to see how other regimes are affecting us, and then tick, tick, tick. I have a privacy policy, I have a data protection policy, I have training models, I have Article 28 contracts with third parties that are processors. Probably I haven't considered joint control scenarios in many cases, but I have a standard contractual classes, which now is the trendy topic this week, and I have all this in place. And now I am seeing from these resolutions, recent resolutions by the Court of Justice of the European Union and regulators' guidance in general, and seeing that now they are kind of guiding us to, okay, you've done this, now is the time to really thinking of how this is really compliant. Now it is time to build this up. And now I think we are going to be asked in general to really carry out proper due diligence, for example, in acquisitions when we are buying companies, to really carry out proper due diligence when we are contracting with processors, when we are putting in place the standard contractual clauses, to really make sure that the other parties is not an obvious sign in the clauses, that actually you have considered the meaning of each clause in the context. So in relation to the privacy by default element. So if it is low risk, perhaps certain measures are okay, and the standard contractual clauses are okay. If it is high risk, perhaps you need to discuss further and make sure that that party agreeing to the standard contractual clauses for this international transfer of data actually can effectively comply with the contract. This is applying to every or each of these contexts, and I think that in considering whether vicarious liability will take place, you need to do the same, and you need to remain really vigilant and keep updating this as to the how. So my key question and recommendation is look at what you've got implemented and ask yourself what I did or what I've done so far. Does it really fit the purpose? Do I know how? Is it stated there, the how?
Excellent. Thank you so much, Rocio. It's really, really great advice there. I think what we might do is we've actually got quite a few questions that have come through. Let's take a look at the questions and then come back for some builds from Helen and Steve before we leave. Yeah, great. Okay, I've got a nod from Steve there, so that sounds good. Okay, the first question is, I'm looking at this from an HR perspective. If an employee makes a remark about a competitor or another employee on personal social media, so I guess I think the question is, you know, is that considered, or could that potentially be considered to be vicarious liability on an employer there? Rocio, Helen, would you like to comment on that one?
I think it depends on the circumstances. That's a classic lawyer's answer, isn't it? Depends on the facts. I mean, what we've been talking about is so the outcome, obviously, of the Morrisons case, as I said, is that an employer can be liable where their employee does something, however misguidedly, in the course of their activities. So the question would be, you know, in what context were those statements or were those posts made? But there is risk in these areas, so you know it's incumbent on employers to think about what they do and what they don't want their employees to be doing in the name of the company.
Yeah, absolutely. That makes sense, Helen, doesn't it? You know, just looking generally as you would at your sort of internet and social media policy, and as Rocio was explaining, just to make sure that these things are actually being applied and they are working and are auditable. Next question here. I think this of course is going back to the Morrisons incident. Given it happened in 2013 to 14, do you feel that the outcome would have been the same under GDPR? That's a good question. Particularly with regards to the inclusion of Article 25 and the relatively cheap and widespread technology available that can restrict and lock down unauthorized USB devices?
So I think that's a great question. I think so is it, obviously it was a Data Protection Act 1998 case, but the relevant provisions are mirrored in the GDPR. So in principle, we would expect a future case arising out of the same sort of facts to have a similar outcome. If anything, of course, the standards for data security for organisations are even more exacting now. What is interesting about the Morrisons judgment, I think, if sort of going back to the 2017 decision, where there is the analysis of the technical organisational measures that Morrisons had in place, lots of them are organisational, I would say, rather than technical. But of course, under Article 32 of the GDPR, in terms of the measures that need to be in place for security of processing, it is incumbent on organisations to take into account the state of the art. So the measures do need to take account of where there may be better technologies that should be put in place. They should be.
Absolutely. I think, Rocio's got something to add there.
Yes, I was just going to add that it's indeed, like Helen said, a very good question, because if the organization does not implement this privacy by default and the Article 32 as well, in terms of the security measures, in terms of primary responsibility, the outcome perhaps might have been different on that sense, if it might be considered that Morrison did not technically take reasonable appropriate measures to avoid allowing the employee to take a copy of that by themselves. So that is something that perhaps it might be argued, and who knows if in a different case, in that sense, it might be slightly different, but it's just a matter of applying it to the case that you are, of course, hearing at the time, and the elements and the measures taken. What we are seeing in regulators and many case law, in which we are seeing that there is being a little more of expectation in terms of security, and in terms of updating the security on a regular basis to ensure this privacy by default and by design being effective.
Absolutely. Thanks, Rocio. And Steve, sorry, did you have a build there as well?
Well, just to emphasise the fact that, you know, a lot of this it is about making sure you have your defence in depth strategy and structure. You know, this is from application down to the sort of, you know, down to the kernel. You've got to really understand a very layered approach, and it's exactly the same as we've mentioned during this episode about, you know, in terms of being able to defend yourself and think about that liability point. So that's all. I was just agreeing and nodding with our guests that, you know, this really is not just the privacy but the security side of it, and obviously now the liability. And interestingly, I note that only today Barclays was it was determined by the Supreme Court that they weren't vicariously liable for a doctor whom they had employed to do screening, medical health screening. So these cases are being brought to court, and unfortunately, you know, there's another example of where sensible, but I sound like a lawyer, but it depends on the circumstances.
Yeah, absolutely. You've segued beautifully there, Steve, into the next question, actually, because this person asks, you know, the court seemed to turn itself inside out when deciding whether or not Morrison's case again was a frolic and how to classify a malicious insider. So the question is, what practical guidance, if any, do we have for figuring out which actions do and do not trigger vicarious liability in data protection? Helen or Rocio, did you want to take that one?
So I think the challenge, which is an ongoing challenge for all those that are tasked or responsible for putting measures in place, is that this is, of course, one case. It will no doubt be referred to in future court cases on data breaches and sort of vicarious liability, and it talks about, you know, was the concept of is the individual on a frolic of their own, but that you know, future cases will still be again decided on their own facts. So there isn't I would say a hard and fast line, and it's wise to sort of take a cautious approach and to put in place the measures that you can to prevent issues arising.
Absolutely. Now this last question, I think it builds on it builds on a question that's already been asked, actually, but I think what we can do is just kind of cover this and then finish with some practical advice from Helen and from Steve, as we've already had such fantastic advice on the top tips already from Rocio. So the person states here that, and they thank you, Rocio and Helen, for your thoughts so far. In the Data Protection Act 1998, the seventh principle in Schedule 1, Part 2, Section 10 states the data controller must take reasonable steps to ensure the reliability of any employees of his who have access to the personal data. However, now under the GDPR, the controller and the processor shall take steps to ensure that any natural person acting under the authority of the controller or the processor who has access to personal data does not process them except on instructions from the controller. Wow, this is quite long, isn't it? Unless he or she is required to do so by union or member state law. I think the ultimate point and question that's being asked here is, given this change, do you think Morrisons or anybody else, for example, would be persuasive at all to similar breaches post GDPR?
Say that definitely under the GDPR and in comparison with the previous requirement of the seventh principle in the Data Protection Act, the requirement is broader, and that's supposed to challenge in terms of, like I said, and actually precisely one of the recommendations of defining the instruction that you are giving to your employee, and narrow it down and ensuring that you take steps to avoid them using the data beyond the instructions is very relevant now, and that's precisely that statement is the reason why we are insisting on that. But we are conscious it's a real challenge, because starting by you give many instructions over the day to many employees who are processing personal data. So in the contract of employment, you don't have a list of instructions, so it doesn't fit on what we are used to do, and therefore, like I said, starting by the high risk processing of data, but this is something that it needs to be considered, and I think that there might be similar breaches, because these breaches happen in fact. Normally there are minor breaches, but we have seen other cases of employees taking data and using it for a different purpose, offering it to competitors, publish it for many different reasons. All of them seems to be or could be fit out of the instructions, but related to them. And I think that under GDPR, the scope in which this may happen is actually broader, and therefore employers really need to consider this point.
Excellent advice, thanks Rocio, and great advice from all of you here. Just before we wrap up then, I think it'd be great just to get some final practical thoughts for organisations and our audience to leave them with. Steve, did you want to start on that one?
Yeah, I think we've covered some really fantastic ground, as I knew we would, with these guests. I think the thing for me, and what I would be doing if I was listening today, as either a CISO or a DPO or in fact a compliance officer, is I would be thinking about revisiting my risk assessment. Understanding sort of maybe putting in some different what if scenarios based on the vicarious liability. I think we've learned a lot today, and I think my advice would be take that back to your risk teams, to your departments, and obviously try to build in some of those considerations for your PIA process, so you can build that privacy by design, and that could be one of the sort of considerations, if you like. I think the second thing with all of this is, you should be, if you're not already, work very closely with your security teams, your security department, and your head of security or CISO. I had the envious position of having both roles. In fact, it wasn't so envious, it was very stressful and sometimes conflict of interest. I would certainly urge anyone in that position to be going back to them and saying, okay, let's really understand how we can ensure that we've got appropriate controls in place with this information that's come to light.
Excellent advice, thank you, Steve. Helen, any builds on that, please?
And just to add, I would agree with what Steve has just said. I would also say, I mean, this challenge or the risk of being vicariously responsible for something that an employee has done and managing that risk has only become more difficult with potentially a dispersed workforce as organisations are grappling with, you know, continuing to work in the midst of the coronavirus pandemic. So there's that additional layer, I think, to be borne in mind as well, and may also necessitate revisiting measures that were put in place and enhancing them.
Yeah, absolutely, a great point to leave us there with, Helen. Of course, it is quite difficult for all of us, and it'll be interesting to see whether there is an increased risk, well, certainly an increased risk, but the outcome of that risk as we all start returning to work. So, Steve, what is in store for us next week before we break for the summer?
Oh, you're asking the right question. I mean, I'm so excited. I mean, it's been a great show. I just knew this one was going to be one of our best. However, I have to say I am really excited to announce that Emma Martins, the Commissioner for the regulator of Guernsey and Jersey, will be joining us live from those lovely sunny islands, and talking to us about all sorts of things. And in particular, we were talking about the role of data ethics and AI, machine learning, and the things that we're grappling with. And from sort of vicarious liability over to sort of profiling, and obviously with yesterday's news with Schrems, so we're going to have a really good time with Emma next week. Now, interesting, this is going to be technically challenging because I will be in Cornwall and I don't know what the reception is going to be like, but I'll be the live correspondent down in Cornwall. So we'll have to see how that goes from a technology perspective, but I'm really excited about that. And anyway, look, I've got our producer Nathan and my business partner there to keep us on track if we lose connection. So I'm looking forward to it. Please tune in for that.
Excellent, thanks, Steve, and thank you so much to our guests. Thanks to Helen, thanks to Rocio, and thanks to all of you for continuing to listen. And we look forward to a fabulous Data Matters at the same time next Friday.